Good afternoon, and welcome to the September 25th, 2024 question and answer virtual luncheon with Jason Killeen. I'm your host, Jason Killeen. I'm an assistant executive director with the Department of Cannabis Regulation. And we're going to go ahead and jump into our presentation about the renewal process for calendar year 2025. Our 2025 renewal process opened on September 2nd of 2024, and the basic renewal fee will close on November 1st of 2024. Late renewals may be submitted, but they're subject to additional fees. The regular renewal period runs from September 2nd through November 1st of 2024. Our first late renewal period runs from November 2nd through December 31st of 2024. Businesses that don't timely renew must cease any operations beginning January 1st if they had a license in 2024 until their renewal is processed. And our second late renewal period runs from January 1st through February of 28th, 2025. If you are not submitting a renewal during the regular renewal period, additional fees will be assessed on your renewal record. When you submit your renewal record, you're responsible for submitting the legal business entity record disclosure form, which is the form 4008. That makes sure that we have updated information about your owners, indirect owners, and primary personnel. You're also required to submit an updated indemnification agreement, which is the form 4005, a successor in interest form if the business is associated with a social equity record. The social equity individual applicant needs to designate a successor in interest so that in the event of the death of the social equity individual applicant, their successor will be moved into an ownership role and the record will be considered social equity as long as that person stays in that role. That form is updated on the legal business entity record, and it's not a form you'll be asked for as part of the basic renewal because it's record specific. But if our analysts, review the record and determine that a social equity record does not have the successor in interest, they will ask you to submit that form. The fourth requirement is for a current business premises diagram, and that is to comply with the requirements of LIC 4024 form. That is information that the compliance team will be looking at as they do compliance inspections on a go-forward basis. We do need to make sure that you have evidence of site control. If you have an existing lease or a property deed that covers calendar year 2025, feel free to go ahead and upload that. If you need to negotiate for calendar year 2025, please continue those negotiations and get them completed as soon as possible so that we have evidence that you have the ability to operate a cannabis business at that location beginning January 1st. And then, of course, the last piece is you need to make sure that the fees that are assessed are paid on or before the due date. As I mentioned before, the LIC 4018 form is only required on social equity records. And to the extent that the form had not been previously submitted to the department, that form is intended to designate a successor in interest for the social equity individual applicant in the event of their death so that that license can continue to be renewed and the department has a contact person outside of the probate process. On this slide, we have the license renewal fees. There's three types of renewal fees. Records need to be renewed. That fee is $1,829. That is for non-operational businesses. We have a temporary approval fee of $4,233. And then we have our annual license renewal fee of $8,486. If you do not timely submit your renewal between September 2nd and November 1st, the system will automatically assess the additional fees for expedited services, because staff will have to work on an overtime basis to get those renewals processed by the due date. Your payment options are: you can make an in-person appointment with the Office of Finance, or you can mail in your payment. The Office of Finance accepts cash, check, money order, credit card. You have to pay the full invoice or the full amount for a single line item on that invoice. So, for instance, a business that has retail storefront, cultivation, and distribution, if the licensee was not going to renew the distribution, they would have to pay the renewal fees for retail storefront and cultivation, and finance will recognize that you didn't pay the fee for the distribution activity, and then that would be removed from the record beginning January 1st of 2025. For in-person payments, you do have to request an appointment, and the email address to request the appointment is going to be on the invoice as well as in our PowerPoint presentation. You need to make sure that you schedule and confirm a payment appointment with the Office of Finance on or before November 1st of 2025 to avoid any late fees. For mail payments, they have to be postmarked on or before November 1st of 2025. Recently, we have expanded the payment processing options to our development services systems, and that service is provided by the Department of Building and Safety. At this time, Building and Safety can only accept cash and check as a payment option, and you have to pay for the full invoice when you go to their payment counters. It's an all or nothing thing if you go to a development services center. So if you intend not to renew an activity, you will have to submit the documentation to reflect that you're not going to renew that activity, so that the invoice can be updated so that you can use the LADBS development services payment option if that's what your intention is. And for additional information about the DBS payment option, we have a link to our website. We've created a PDF document that will walk you through the step-by-step process to navigate our renewal process for A&N records as well as for LIC records. The link is available on our website. It's linked under PDF document on this PowerPoint presentation, which will be available after the Q&A, and it's going to be included in future communications that are sent out about the renewal process. I do want to invite folks to register for an event that our social equity team is going to be doing on October 10th from 10 a.m. to 3 p.m. The event is called Pitch Perfect, and it's going to feature a subject matter expert, Jake Kucharik, to host a panel discussion on elevating the pinch deck and secure funding for social equity applicants that are looking for capital to run their business. Lunch is provided and there is free parking. Please register for this event and support our social equity program. And with that, I'm going to turn it over for the question and answer session.
Good afternoon, Jason. Our first question comes from Orlando P. Is the city waiving license fees, and does the state still have a waiver in place?
So We have limited grant funds to waive the annual license application fee for social equity applicants pursuing the Type 10 retail storefront. Other than that, applicants would have to pay application fees. Separately, the Department of Cannabis Control has their own grant programs, and they do have waiver programs for social equity applicants. I would recommend that you reach out to the Department of Cannabis Control to see what their waiver policy is currently. General applicants, unfortunately, will have to pay all applicable fees.
Our next question from Victor G. What are the fees every year after you get a license? And do these fees get waived if you are a social equity individual?
The renewal fees are based on where your record is in our process. For a business that has to renew the record, that's one set fee. For a business with temporary approval, that's one set fee. And then for a business with an annual license, that's a separate flat fee. Those renewal fees are not waived if you're a social equity individual applicant. So anybody who has been, determined local compliance underway through an annual license will be responsible for paying their renewal fee.
From Paula B. What are the next steps for phase 2 non-retail licenses moving from temporary approval to annual license in order to transition the provisional state license to annuals prior to DCC provisional license cutoff date?
It's going to be a process similar to the retail storefronts. For the non-retail applications, those reports go through me, and I have the authority to sign off on the reports and grant annual licenses. DCR staff are prioritizing the non-retail records based on when the state provisional license will expire to ensure that folks have the ability to transition from provisional licensure to annual licensure. It is important for folks to pay any applicable fees that have been assessed. We have been notified by the Department of Cannabis Control that local jurisdiction assistance grant monies cannot be used to waive annual license application fees. So those fees have been assessed or will be assessed in the coming days. And then it's important for you to make sure that those fees get paid so that you do get your determination as well as adopted environmental report that you can provide to the state.
Our next question comes from two individuals, Paula B. and Tamika D. When will phase 2 non-retail licenses be receiving notices of determination / CEQA exemption documents from DCR?
Again, great question. We've been notified by the Department of Cannabis Control that LJAG funds cannot be used to waive annual license application fees. We've begun to assess the annual license application fees to all records, and the payment of those fees and any applicable review fees, including environmental, need to be paid in order to get your notice of complete application and your determination from the department plus your adopted environmental analysis. So if you get an invoice, payment of that invoice is going to drive how quickly you're able to get a notice of complete application as well as the required environmental documentation to satisfy the state.
Our next question also has to do with CEQA from Diana E. Applicants who have state provisional licenses and have not received their annual license or final CEQA documents, how can they proceed with renewing their state provisional license?
The Department of Cannabis Control is allowing existing provisional licensees to renew their existing records through the end of this calendar year. Um, and whenever your state provisional license expires in 2025, you can no longer renew your provisional license. We're working hand in hand with the Department of Cannabis Control based on the list of businesses that have state provisional licenses to determine the priority for processing those local annual license applications to ensure that businesses don't have to shut down in the event that they have to convert to a state annual. That said, there are going to be fees that folks have to pay because unfortunately LJAG monies cannot be used to waive application fees, and it can only be used for environmental review. So to the extent that you receive an invoice for your annual license application or related fees, it's important to make sure that those get paid so that your record does not get abandoned and that your record can be processed so that you have the documents to convert from a provisional license to an annual license.
A question from Philip A. Excuse me. Can a non-social equity applicant purchase a license from a social equity applicant?
A non-social equity applicant can purchase equity in a social equity applicant, but that ownership modification will only be approved provided that there is a sufficient number of social equity individual applicants to meet the requisite equity share for social equity when that modification gets processed. So, for instance, a tier one record would require 51% of the ownership to be tied to a bona fide social equity individual applicant. So if we get a modification request that has 80% owned by non-social equity applicants and 20% owned by existing social equity individual applicants, that would be denied because that does not meet the requirements under the code for that record to have at least a 51% stake owned by social equity individual applicants.
Question from Renee R. I was told that retail licenses now will need an LA County Health Department certificate by the end of the year, but without that certificate of use permit by building safety, I can't even apply for the county health permit. That step can take more than a year. What happens if I don't meet the deadline?
So that is not a new requirement. When the city and county executed a contract for county health to provide health inspections and health permits for cannabis businesses, that was a date certain. The department is submitting a report to advocate for an amendment to the municipal code to extend that period of time to allow for folks to, um, you know, demonstrate that they are in the process of meeting the requirement to get their health permit and their emblem. But that will be a policy decision, and that'll be something that's before our planning and land use management committee and city council before the end of the year. Um, you know, at the end of the day, we can recommend amendments to policy in the municipal code, but we can't unilaterally implement it. So for businesses that would be impacted by this deadline, once that report gets transmitted and it's before the policy committee, it would be important for you as stakeholders to reach out to your council office and to the city clerk to advocate for your support of that bill to extend that deadline.
Our next question comes from Bertha S. What should we focus on with CEQA review when applying for a license?
The most important thing is to complete the LIC 4013 form in its entirety. That document was negotiated between our department and the state for completeness for environmental related questions. So the more information you provide in that form, the more information that we have to analyze to determine whether or not your project would be eligible for a categorical exemption. Projects that are not eligible for a categorical exemption will have to go through an initial study to determine the appropriate type of environmental review for the project. And that is time consuming and it's costly. So please provide us as much information as possible on that 4013 form.
A follow-up question from Bertha S. Why does the environmental review include a question about power consumed by the previous renter?
So on the 4013 form, one of the things we're looking at is the prior use. So for an existing commercial facility, the question about the power usage is to demonstrate that there's a negligible impact between the prior use and the current commercial cannabis use. And to the extent that an existing facility or an infill project categorical exemption could apply to your project, that's part of our review and analysis. If you had a blank piece of property and there was nothing on it, and you were building a large cultivation facility, then your energy usage may or may not be supported by the grid. And that analysis may or may not lead to our ability to apply categorical exemption to your project. So that's why we ask those questions.
Thank you, Jason. This question comes from several individuals, Justin P., Ignite D., and David U. We have an application that has been in environmental review. We were told we would receive an email from DCR regarding it. When will that email go out?
So the department is still in conversation with the Department of Cannabis Control. The Department of Cannabis Control is the grantor for the local jurisdiction assistance grant. We are trying to determine what the state is willing to waive in terms of environmental related review fees. And the state has indicated that until an amendment gets adopted, we are precluded from expending those funds. For businesses that are not willing to pay tens of thousands of dollars to have that environmental review completed, you'll have to wait for the DCC to make that determination. If you are not willing to wait and you're willing to pay those fees, please talk to your analyst and we can go ahead and assess the $8,000 consultant review fee and the $2,000 plus environmental review fee so that we can begin that analysis immediately. But if you are not willing to pay those fees or you want to see what the Department of Cannabis Control is willing to authorize us to use the LJAC funds to pay for, unfortunately, you're going to have to wait until they make that determination.
Thank you. Diana E. asks, applicants who have state provisional licenses and have not received their annual license or final CEQA documents, how can they proceed to renew their state license?
So this is going to be a one-off based on who your state analyst is, but generally, if you have a state provisional license and you're renewing it in calendar year 2024, evidence that your project is under environmental review should be sufficient to renew your record into calendar year 2025. Just like with our department, different analysts have different understandings of the requirements, so that if your evidence that your local compliance is underway and DCR is actually doing the environmental review is not sufficient for you to renew, it's going to be good to reach out to your state analyst and your local analyst to make sure you get that documentation that the state is looking for to satisfy the renewal requirement.
From Ignite T, what will happen to social equity applicants who are still in review status come 2025?
At the local level, the city council adopted processing deadlines, and the intent was to guarantee that records would be processed in a specific period of time. The licensing team is going to be doing a final review of pending licensing records, and records that are not being filed by the end of the calendar year are going to be subject to abandonment, and no further extensions will be provided. To the extent that the record can be refiled, you'll have the ability to refile it. But, records where you have not met the minimum filing requirements will be abandoned. And unfortunately, if the record is not deemed filed in the first place, it's not eligible for refiling. And December 31st, 2024 is going to be a hard deadline, that if people are not meeting those application requirements, unfortunately, those records will be abandoned.
Our question from Diana E. Is there a deadline for Phase 3 retail Round 2 applicants to submit a pre-application?
Yes, there is. The Phase 3 Retail Round 2 lottery was conducted in December of 2022. Originally, folks had 1 year from the date that they were selected to participate to file their pre-application. The city council extended that to 3 years. So by December 7th, 2025, folks that were selected through the Phase 3 Retail Round 2 lottery need to have submitted their pre-application records. If you have not submitted your pre-application record by that date, your lottery record will be closed and you will not be eligible to apply for the Type 10 retail storefront activity.
Another question from Diana. Can an applicant submit a modification request for ownership change if the applicant has not received temporary approval yet?
The simple answer is no. If a modification record is submitted to change ownership on the legal business entity record, that would suspend processing of any application records. So the type of record itself and the requirements for ownership changes on that record would drive whether or not the modification request could even be considered, let alone processed.
Rick J has a question. I have a micro business with no retail activities. For the annual application, may I use the non-retail process?
So this is a great question, and it's very nuanced. The micro business license type is unique to the state of California. The Department of Cannabis Control will issue a micro business for a business that has at least 3 commercial cannabis activities at a singular location. At the local level, each activity has to be applied for individually. So we if you have distribution, manufacturing, and cultivation, each of those activities have to be renewed and reviewed at the local level. So if you don't have a retail component, you're already applying for the individual activities you're engaged in at the local level. And if those activities are not retail, they would be processed pursuant to our non-retail process.
Thank you, Jason. Our next question from David P. Uh, were phase 3 retail, oh, I'm sorry, I'm trying to decipher this question. Can we receive our provisional from DCC and get temporary license from DCR to go operational without having a community hearing?
So Senate Bill 51, adopted by the California State Legislature and approved by the governor, allows the Department of Cannabis Control to issue provisional licenses to social equity retail applicants through, I believe, 2031. So if you are a phase 3 retail applicant, you would have to, by definition, be a social equity applicant, and you should be eligible to pursue a state provisional license under SB 51. If you can get a state provisional license, you would be eligible for temporary approval, which would allow you to begin operating prior to getting a full annual license, which in turn means that you would begin to operate before you've completed a community hearing and or public hearing.
A follow-up question from David. What is the DCR timeline for temporary approval after receiving the provisional from DCC?
It's really on a record by record basis. If you've already completed your initial inspection and you provide evidence of your state provisional license, we can grant temporary approval. If you have not completed your initial inspection, when you submit your evidence of a state provisional license, you still have to pass an initial inspection before you're eligible for temporary approval. And you can request that through your DCR licensing analyst. Generally, if you provide the 3, dates that your business is available for that initial inspection, the licensing team is able to get that inspection scheduled within 1 to 2 weeks.
Thank you. From Narek B. If the license record status is still temporary approval, when should we anticipate receiving annual license, and what are the fees?
Good question. It's going to depend on the activities on the record. We're working again hand in hand with the Department of Cannabis Control, and we get updated provisional license lists from them on a quarterly basis. And we're prioritizing processing based on when folks' provisional licenses would expire in calendar year 2025. Between October 1st and the end of the calendar year, we're going to process the majority of our non-retail license applications. And, to date, the Cannabis Regulation Commission has had the opportunity to consider over 200 retail storefront businesses. So we're really trying to prioritize our local workload based on the state's deadlines. DCR still has the ability to renew temporary approval through calendar year 2025. So businesses can maintain their temporary approval while they work towards annual licensure. If you have questions about a specific record, I definitely would recommend reaching out to your DCR analyst, because each record has a unique deadline for when they're going to have to convert from a state provisional license to a state annual license. And where you are in our local process is really dependent on that date. So in general, we're trying to make sure that everybody converts, so that they have their state annuals prior to the expiration of their state provisionals. And the fees are set by code, and really, at this point, it depends on whether or not you have an existing state provisional and you're eligible for, different fee waivers under LJAG versus you don't have a state provisional and you would have to pay all of the fees articulated in Municipal Code Section 10419.
A question from Mallory W. Do you have to obtain a license if you're working under a business that manufactures cannabis products but do not plan on operating a storefront?
A business engaging in commercial cannabis activity needs to have a license for that commercial cannabis activity. If you are a employee of the licensee, then the licensee's license covers your engagement in the commercial cannabis activity. If you are a business entity that has a contractual relationship with a commercial cannabis business, most likely you would need your own commercial cannabis license to provide services to that entity.
Another question from Mallory. How are cannabis brands monitored and tracked without a store involved?
So, the Department of Cannabis Control, the state agency, has a track and trace program. And that track and trace program is intended to track and trace seed to sale. So businesses that are engaged in non-retail activities prior to the sale of cannabis to a consumer is tracked through the state system, and that's how it's monitored.
Did I ask a question about track and trace? I'm sorry, I lost track.
Yes, you did.
Okay, great. Sorry about that. Next question from John L. Can applicants still get temporary approval?
Certain applicants, specifically social equity applicants that are eligible to get a state provisional retail licenses, would be eligible for temporary approval. Businesses that are not applying for a retail activity and social equity applicant through the state must demonstrate that they have a state provisional licenses to get temporary approval.
Next question from John L. What are the most common mistakes applicants make during the licensing process, and how can they be avoided?
The most common mistake is really just not submitting the required documents and forms to the department. by and large, if you submit everything necessary to satisfy the municipal code and the rules and regulations, the department is going to deem your application complete and recommend approval. The only time we would not recommend approval is if your business triggers one of the things under the municipal code that are grounds to deny a license. But submitting documentation, being responsive to your analyst, making sure that any deficiencies in your forms are corrected, is the biggest roadblock between an applicant receiving a license and an applicant having their application deemed abandoned due to deficiencies.
Question from Jesse F. When is DCR planning to submit the motion to City Council regarding opening the cultivation license process, as well as the next retail lottery?
We have draft language for all of those items. Ultimately, those are changes that have to be done at the legislative level. And if there's not support for those items, we have to kind of pick and choose what recommendations we as a department make to the city council, because recommending something that is dead on arrival with something that we need to absolutely happen means that that entire policy fails. So we have a series of recommendations that are prioritized. As mentioned in one of the prior comments, getting the city council to consider an extension of time for the public health requirement is first and foremost for our department. Given the proliferation of unlicensed businesses, having licensed businesses have to shut down because they have not met that threshold means that consumers will be forced to purchase from unlicensed businesses, and those products aren't tested. So that creates a huge public health and public safety issue. So first and foremost, resolving that issue is our top priority. Secondly, we have the priority of seeking an extension to the exclusivity period for social equity applicants, which would include the retail storefront and cultivation activities, such that the city council could consider a modification to the equity share and social equity individual applicant requirements, to make that process federally consistent, to say the least. And those go kind of hand in hand. You can't have one without the other. That is a larger policy consideration than just extending the deadline for the health permit. And then we have all kinds of other regulatory things that we would like to update to streamline our process. Our director is committed to transmitting the reports as soon as possible. And she has been in communication with different policymakers to try to facilitate that. So additional information will be forthcoming. Our top priority is to extend the performance period for the public health permit. And then our second priority is really being able to update the social equity individual applicant criteria, extend the exclusivity period, and be able to regulate a lottery process for cultivation and retail storefront.
Our next question comes from Shelley D. What is needed to begin the process to open a dispensary?
First and foremost, opening a retail storefront business requires you to have been selected as an eligible social equity individual applicant to submit a type 10 application. There's information on DCR's website about our application process and the licensing requirements. So for this specific question, I would refer them to the website.
Thank you, Jason. Our next question comes from uh, Devin B. Beginning on January 1st, 2025, will individuals who were never verified as social equity applicants be eligible to own 51% or more of storefront retail licenses?
For that, I mean, for this question, the answer is it depends. A individual who is not verified has the ability to purchase equity in a non-social equity license for whatever amount. The social equity licenses still have to comply with the requirements under 10420, and they continue to be a social equity license currently into perpetuity. So a non-social equity applicant could not buy a 51% stake in a phase 3 retail round 2 business because that business would no longer comply with the equity share requirements. So that ownership modification would be denied. So it really depends on the license type that the individual is trying to buy into. But a non-social equity record, there's no limitations on, you know, people buying into it, provided that they don't own 3 or more retail storefront licenses. And then for social equity licenses, the license itself has to maintain the required equity share requirement.
Did you have anything to add to that question, or should I move on to the next one, Jason?
Nothing to add.
Okay. From Ariella J. If a licensee is paying an annual application fee, shouldn't the license have at least 1 year to operate before having to pay a renewal fee?
That's not the way the municipal code works. The municipal code has a hard deadline for all records of December 31st of that calendar year. And the code requires records that have been filed to be renewed on an annual basis, whether it's a pending record or it's been issued temporary approval or an annual license has been issued. So based on the municipal code, the application and licenses issued don't run for 365 days from the issuance. They run based on the calendar year.
Another question from Ariella. When DCR approves the annual application and updates the record to LIC, when will the licensee receive the physical annual license to hang at the premises?
That is a great question. We have a template for digital copies of the LIC record that show the operating status that will be uploaded to applicable records sometime next month. There's a larger conversation that's happening in terms of what that physical LIC record, if applicable, would look like. From a bureaucratic perspective, generating a PDF document on the applicant's record that they could go ahead and present, print and then post at the local business, location is the easiest to administer. Unfortunately, that is easy to replicate and to create counterfeit licenses. So, working with various partners, there's a discussion about creating a more tangible physical license that gets created, kind of like a license plate that would be issued to a vehicle that, stickers are issued on an annual basis, but you have some like tangible hard copy thing that's harder to replicate. Um, and as we kind of work towards the 2025 calendar year, we're going to continue to have those conversations, but digital copies should be uploaded sometime in October.
Jason, I wanted to check on your time because we do have quite a number of questions to go, maybe like 50 more. We had a lot of questions this time, so I wanted to check on your time.
What does your timing look like?
Um, I'm okay. I'm not sure. Let me check with staff.
Okay, why? I have a hard stop at 2, and I can make myself available until like 1:45, um, provided other folks are still able to support this call.
Okay, I'll continue with questions and we'll figure out timing and make an announcement. This question comes from Ariella J. Is there an application inspection fee built into the annual application fee and the annual renewal fee? If yes, does that mean the licensee is paying for two during 1 year?
The inspection fees are not built into the application renewal fees. We do have an a la carte fee that gets assessed for businesses that are in an operational status, and that fee is assessed separately. On this specific question, businesses that were operating in 2023 and subject to a compliance inspection in 2024 were assessed a separate inspection renewal fee. And I know we're still getting our compliance and enforcement division up and running. So some of the businesses that have paid that fee have not been inspected. So we are intentionally not assessing compliance inspection fees for 2025 as part of the basic renewal process, so that we can make sure that folks are not assessed two inspection fees when we haven't, provided the service for the first one. So hopefully that helps.
Thank you. Next question again from Ariella. If the applicant paid the inspection fee at the last renewal last year, but has not yet undergone a compliance inspection during the 2024 calendar year, will a second inspection fee be required for 2025?
Sorry, I overspoke on the last question. To that exact point, if we assessed a fee for calendar year 2024 and we haven't provided the service, the intent is not to assess the fee for 2025 until we've provided the service.
Again from Ariella. How can a licensee apply for an operating permit if it already satisfied all of the criteria?
I would refer you to our website. There's a section on getting an operating permit, making sure that you have your certificate of occupancy, your public health permits, etc., are going to be necessary to request your final inspection. And then the final inspection is the last component before an operating permit is issued. So for the sake of this Q&A session, I'll refer you to the website, but if you have follow-up questions, please contact TCR Licensing or reach out to our compliance team.
Ariella asks, How can a licensee pay for only some of the invoiced application activities? Um, and then does the invoice need to be reissued prior to September 29?
Good question. If the invoice is processed by the Office of Finance, provided individual fees are paid for, they'll accept the invoice. So if you were issued an invoice for 4 activities, but the business is only going to pay for 3 activities, the Office of Finance can facilitate that. And then ultimately, once the 4th activity, the period of time to pay for it has lapsed, that would be removed from the record. Separately, the Department of Building and Safety, through the Development Services Centers, they only have the ability to process an invoice in its entirety. They can't do a la carte. So if you're trying to pay some of the fees, you need to make the appointment request with the Office of Finance or mail in your payment and indicate what fees you're trying to pay through that payment. If you try to pay through Building and Safety, you have to pay the entire invoice.
Thank you, Jason. And I've just been notified by staff that we could stay longer. So thank you for staying. Our next question from JB. Is there a contact person you can recommend for cannabis payment processing or point of service?
I don't quite understand the question, so I'm just gonna spew a bunch of information. As like a regulatory entity, we can't provide business recommendations. And, if you're operating a cash only business, there are different courier services that can pick up cash from your location as well as deliver payments to other locations, such as the Office of Finance. But that would be something that you would have to negotiate with a third party. The Office of Finance and the Department of Building and Safety both accept cash payments. For finance, you have to schedule an appointment. For building and safety, they will accept walk-in cash appointments. But how you pay your fees or your taxes is really a business decision.
A question from Rabin W. What is the process for adding a delivery to an already annual licensed retail location?
If you want to apply for a standalone delivery license, you'll have to submit a new application record. If you have a license for type 10, which is the retail storefront activity, within the umbrella of that license, you can engage in delivery activity. But if you want to apply for a standalone type 9 license, it would require you to submit a new application record.
Question from Rabin. Will there be another retail opportunity this year, and when will that be?
It's unlikely that we would conduct another retail lottery this year. Under the current code, we are seeking amendments in the municipal code, and the adoption of those amendments, as well as when it gets considered by policymakers, is really going to drive our ability to offer up additional retail opportunities.
From JC, is there a cap on how many licenses will be given out per year?
There's not a per year cap. retail storefront, the type 10 record, and cultivation activities are capped by community plan area. And, those caps are set by the municipal code. So there's not like a new refresh of records or licenses that come available every year. It's really working within the existing framework before undue concentration is met in a given community plan area.
This question comes from Alexa J. There has been a portal system error when uploading documents for annual renewal, and when the system allows for document uploads and a full submission of renewal records. Most of the time, the invoice is generated with a zero balance due or error message. Is DCR working to fix this?
The simple answer is yes. We've worked with the system provider Excella, and the those issues should have been resolved as of September 24th. The uploading of the documents, that was something that was hard for us to replicate. So we removed some of the restrictions, which should enable people to upload the documents. For the assessment of the fees, originally it was intended to convert people from the A&N process into the LIC record type in calendar year 2024, and we're still working towards that. So to the extent that 2024 renewal fees were assessed on a record, that was preventing 2025 renewal fees from being assessed. And, again, once that issue was reported to us, we worked with the Excella team to resolve it. And everything seems to be working as intended. We will be running a set for folks that submitted a renewal record that may have gotten a $0 balance or error message later this week to make sure that they have an invoice generated that has the applicable fees.
Thank you. Alexa J asks, will DCR be issuing 2025 temporary approval certificates after a renewal record is reviewed and approved?
Yes.
Next question, Desiree B. Why do we get a seller's permit and tax certificate to check if an address is approved for sensitive uses?
The simple issue is the fact that there are restrictions at the banking level for cannabis activities requires us to rely on the Office of Finance to provide cashiering services. And in order for the Office of Finance to accept payment, an applicant has to have a valid business tax registration certificate. And to demonstrate that that entity that is paying the fees is properly registered with the state, they have to have that seller's permit. So in order for somebody to apply for or submit an application to engage in commercial cannabis activity, you have to demonstrate that you have that seller's permit and tax certificate.
Our next question comes from Desiree B. Why is there not a time frame for address approval?
If there's a specific record they're inquiring about, I would recommend reaching out to the applicant to see what deficiency may exist for that particular record.
Question from Christy W. How long does it take to get your license renewed?
Generally 30 to 60 days, depending on when you submit it.
And also from Christy, how many different types of licenses can one apply for?
It, at this point, it depends on whether or not they're a general applicant or a social equity applicant. We have some businesses that are authorized for 4 distinct activity types at a singular location. Um, we may have some that have like 5 or 6 for taxation purposes that include nursery. But generally 4 is the most that I've seen most individual businesses have.
Fabio F asks, LAMC 104.06 states that Type 10 licenses shall be limited only to social equity applicants until January 2025. I'm an operator and an annual license holder that owns 51% equity in my business. Will I be able to transfer or sell my equity share to a non-social equity partner after that date?
No. So the exclusivity period for social equity individual applicants or social equity applicants to apply for certain licenses expires on January 1st of 2025. That does not change the fact that licenses issued subject to 10420 social equity licenses have an ownership requirement that runs into perpetuity. So in 2025, general applicants would have the opportunity to participate in lotteries for things that are currently limited to social equity individual applicants. But licenses, social equity licenses, still have to meet the requirements of 10420, and ownership modifications have to comply with those requirements in order to be approved. So a social equity license cannot be converted to a general license on January 1st, 2025, based on the current municipal code.
Thanks, Jason. Another question from Fabio. Is there a mechanism with the DCR to pause my Type 10 license from being operational?
I mean, the simple answer is a licensee may be non-operational for up to 6 months. But once you've been operational for more than 6 months, you're no longer eligible to renew your license. And, DCR worked with policymakers to allow for expired licenses to be renewed within 3 years of the expiration of the license. So ultimately, if you are non-operational for more than 6 months, it's going to result in you not being able to renew. And at some point, that license is going to expire. And when you're ready to reconsider becoming operational, you would have to refile an application to become operational.
Christian C asks, how is DCR currently managing social equity retail provisional temporary approval applications since the state adopted SB 51?
Simple answer is Senate Bill 51 gives the Department of Cannabis Control the authority to issue new state provisional licenses to social equity retail applicants. In order to get temporary approval at the local level, you need to demonstrate that you have a state license. So if you meet the requirements to get a state provisional under SB 51, once you've gotten that state provisional, you can request your initial inspection. And upon passing your initial inspection, if you haven't already done it, you would be eligible for temporary approval. But you're going to have to meet the Department of Cannabis Control's requirements to get a provisional under SB 51 in the first place before you would be eligible for temporary approval at the local level.
Christian C. asks, what does the current state and city of Los Angeles ordinance say about how many years a provisional temporary approval license can be renewed before having to transfer into annual license application?
So they're completely separate regulatory schemes. The Department of Cannabis Control does not have the authority to renew provisional licenses in 2025. So when a provisional license expires in 2025, that operator must have converted to an annual state license. We are working with the state and operators to try to ensure that our local operators that have a provisional license have the necessary local documents to convert to annual, but before their 2025 expiration date.
A question from Paula B. If we need to make ownership changes to a license, should we do that as part of the renewal application or a separate ownership modification request?
It'll have to be done as part of a ownership modification request on the legal business entity record. Owners, indirect owners, primary personnel, that information is stored on the legal business entity record. So a modification should be submitted against that record when things change.
Again, from Paula B. If an applicant, a TA applicant, is considering relocation due to landlord lease issues, is there any mechanism to renew a license for 2025 without evidence of site control? Can the owner put a license in limited operation status or something while we look for an alternate location?
No. So if a business has been issued a license and you lose site control, that license would expire at the end of the calendar year. And then the business has the opportunity to refile a new application when they find a new compliant location. So if you have a license, you can't continue to have a license to operate at a location that you can't operate at. The license would just expire, and when you identify a new location, subject to the refiling requirements, if you meet them, you can refile a new application.
Mike S. asks, when will licensees who do not have retail activity receive an annual license application fee invoice? If my understanding is correct, DCR will not be providing CEQA exemption documentation to DCC until non-retailers have paid their annual license application fees.
Having heard that question for the first time, that all seems accurate. We provided the Excella team a list of non-retail records that needed to have their annual license application fees assessed. And by the end of next week, those fees should be assessed and invoices should be generated. Once the application fees have been resolved, we're still working with the Department of Cannabis Control on what environmental CEQA related fees can be waived using LJAG funds. If you don't have a provisional license, you're not eligible for LJAG waivers, so they'll have to pay fees. But for existing businesses that have a provisional state license, there may be some subset of environmental fees that will be covered by the LJAG grant that you may not have to pay. Over the next 3 months, our priority is going to shift from looking at the retail storefront records to the non-retail records and prioritizing getting those processed to the extent possible before the end of the calendar year. So, to Mike's question, fees should be assessed in the near future. Payment of those fees is going to drive how quickly we process it. And then, of course, the expiration date of the provisional license of DCC is going to be the tiebreaker on how quickly things get processed.
Another question from Mike S. Are all social equity businesses going to get the annual license application fee waived?
No. A social equity applicant would only be eligible to have their type 10, which is the retail storefront activity, waived. If they've applied for the type 9 delivery or any of the non-retail activities, unfortunately, we do not have any grant funding to waive those fees. They'll have to pay them.
Thank you. Levon E. asks, if a retail Type 10 application received a status of temporary approval, this means that the applicant has their slot locked into the community plan area, correct?
I mean, by and large, that's correct. When temporary approval, which is the license, or the annual license application fees are paid, generally that links a record to a community plan area. And if the applicant loses site control, they would have the ability to refile within that community plan area and not be subject to a finding of undue concentration. So without more information, once the application is deemed filed in a community plan area, it's there. And if it gets refiled, it can be refiled there. In terms of the issuance of a license and stuff, there's a bunch of different factors that drive whether or not we can issue a license. So hopefully Levon has more information or information that addresses his question. And if not, I would invite him to ask a follow-up question.
This question also comes from Levon. If an applicant is one of those 12 sensitive use refiles, do these refiles count toward undue concentration?
It depends. The municipal code has language specifically for phase 3 that identifies whether or not a record counts towards the calculation of undue concentration. So the phase 3 records and refiled phase 3 records may or may not be included in the calculation of undue concentration. And it's really reviewed on a case by case basis based on the record and whether or not they meet those requirements. There's not a one size fits all rule that applies to this question.
Our next question comes from David P. It's regarding Form 4013. Do I need to visit the city department to obtain this, or does your team handle the evaluation and submission? DCC is requesting the notice of exemption, and I want to clarify the process.
This sounds like an application specific question. So I would recommend David reach out to the analyst processing this record to see where the record is in this process. The 4013 form, which is our local project-specific information form, is processed in parallel with an annual license application. And those forms are included in the staff report that go to the Cannabis Regulation Commission or the staff reports that come to me for the non-retail activities for approval. So it really depends on where the record is. But the process in the 4013 form can't be done separate and apart from a determination to issue an annual license.
Also from David, if we get the initial inspection and pass, can we open with temporary approval, or does the state require notice of exemption from CEQA, from DCR, plus the initial inspection, then allow temporary approval?
To lawfully operate, you must possess a local license, whether it's a temporary approval or an annual license and operating permit, and a license issued by the Department of Cannabis Control. Certain businesses have the ability to get a state provisional license, which DCR has no authority or control over. At the local level, if you demonstrate that you have a state provisional license, you would be eligible to request temporary approval, provided that you pass an initial inspection. So temporary approval and a provisional license are one process that allows a business to operate before they've met the requirements of the annual licensing process. At the state level, SB 51 only grants the Department of Cannabis Control to issue new provisional licenses to social equity retail applicants, type 10, type 9. If you are not that type of applicant and you do not have an existing state provisional, you will have to get your local annual license and then get a state annual license to qualify you to request an initial inspection to try to get temporary approval at the local level. But you're going to have at least 2 operating licenses before you can lawfully operate.
Next question from Diana E. Are the applicants going to pay separate fees for the 2025 license renewal and the annual license?
Yes.
Next question from Diana E. If phase 3 round 1 applicant has an application with the status abandoned, refile eligible, can the applicant submit a modification request for ownership structure change or entity substitution with the LBER record number before reapplying?
I would reach out to the assigned analyst. The application status of abandoned eligible for refile doesn't give me enough information. The municipal code requires the qualifying social equity individual applicant to remain on a record until such time a license is issued. So there are going to be factors that staff would look at before determining if a modification request can be processed. But any ownership or primary personnel modification request does have to be submitted against the legal business entity record.
Another question from Diana E. Excuse me. If the retail applicant needs to submit a request for change of use and then get a health permit and the emblem placard, can they operate after 1/1/2025?
Under current law, a retail storefront business that does not have their health permit and emblem placard will have to cease operations on 1/1/2025 until they meet that requirement. We are seeking a revision to the law to allow for folks to continue to operate. But if the law is not amended, folks that do not have a health permit and an emblem placard that are operating a retail business will have to stop operating.
From Mike S. It's a long question, so if you need me to repeat any portion, let me know, please, Jason. From Mike S. I'm having difficulty with the definition of indirect owner. I'm under the understanding that an indirect owner must have at least 20% aggregate ownership interest in the applicant entity in order to be considered an indirect owner. However, the definition also makes it seem that if the person which has any ownership interest in any entity that has at least 20% ownership interest in the applicant will also be considered an indirect owner. Can you please clarify if a person with less than 20% aggregate ownership interest in the applicant qualifies as an indirect owner?
A person with less than 20% equity in the applicant or licensee is not an owner. And for the local level, an owner is somebody who has a 20% or more equity stake in the applicant or licensee. And in kind of more colloquial terms, it's a level one owner. So if, DCR is the applicant and Michelle Garakian is 100% owner of DCR, she is the owner. Now, I work for Michelle, so like if I have some equity that's a subset of Michelle's equity, I'm a level two owner. So if that equity is less than 20%, I'm just a financial interest holder. If it's 20% or more through Michelle's ownership, I would be considered an indirect owner. So to Mike's question, an owner by definition under the municipal code has to be somebody who has a direct 20% or more equity stake in the applicant or licensee. If that equity is held through an intermediary entity or other person at level two down, they would be considered an indirect owner if that aggregate equity is 20% or more. And if it's less than 20%, they're considered a financial interest holder. So hopefully that gives Mike enough information to address his question.
Thank you, Jason. Moving on, another question from Mike. Many records are showing an outstanding balance of $7,691, but there is no invoice attached to that record, and no email has been sent to notify that fees are due. Can you clarify, please?
If it's a phase 3 retail round 1 or retail round 2 record, we have grant funds from the governor's office through the cannabis equity grant to provide waivers for application fees for social equity retail storefront applicants. So in that event, the fee has been assessed against the record, and a communication should have been sent saying that certain folks are eligible for a waiver under the CEG grant program, and our staff is beginning to apply those grant waivers. For calendar year 2024, we didn't get all of the grant monies as one payment. It's broken up into 4 payments. So we have to basically exhaust the first payment, provide evidence to the state before we get the second tranche of payments. So if it's a phase 3 retail round 1 or a phase 3 retail round 2 record, we didn't generate the invoices because it's our expectation that we would use grant funding to provide a waiver. If it's not one of those record types, please reach out to your analyst so that we can make sure that you have access to an invoice.
Question from Lennon V. Is there one place on your website to gain information about all permits, licenses, and requirements that are needed to start a cannabis business?
There on our website under the licensing section, there's documentations tied to procedures and resources for DCR related activities. Depending on the activity you're applying for is really going to drive what types of other permits, fire permits, building and safety permits, etc., you would have to get. All commercial cannabis businesses have to get a health permit. So there is information on the website about that. But that information does live on different parts of our website, not necessarily on the same web page.
Another question from Lennon V. Is an industrial wastewater permit from the City of Los Angeles sanitation required for my business?
I would reach out to the Department of Public Works Bureau of Sanitation to determine whether or not they require a permit. Activities like cultivation would require a wastewater permit in addition to your health permit. And to get the health permit, you may have to demonstrate that you have your wastewater permit. Again, DCR can help guide you to what departments you may have to work with to meet all of the permitting requirements. But we can't accept permits and or process permits on behalf of those departments. So, I would invite you to reach out to either the Bureau of Sanitation or to your analyst so that they can make a referral to the applicable department to get your question addressed.
A question from Christian. According to DCC, an applicant needs to have a business address to request a seller's permit from CDTFA. If we are starting the LBER and do not have a property address, how can we complete the LBER without receiving a seller's permit from CDTFA?
The answer is you're going to have to identify an address. And what I've seen other businesses provide to CDTFA and the Office of Finance is a residential address for the creation of that entity. And then ultimately at the local level, when you want to apply for a commercial cannabis activity, you would notify the Office of Finance of where your proposed business premises location is so they can create a location code under your master BTRC for that to allow for you to submit a pre-application record for DCR review. But ultimately both finance and CDTFA require some address to be registered, and then what address gets chosen becomes a business decision prior to the submission of a commercial cannabis application.
Jason, you said 140 or 145 is your cutoff?
145.
Okay. John J. asks, is there an equity fee waiver with the DCC and one with DCR, or is there one equity fee waiver that can be applied for?
DCR only has California Equity Grant monies to provide waivers for the Type 10 retail storefront activity for bona fide social equity applicants. The Department of Cannabis Control has fee deferral programs, and they may have fee waiver programs that social equity applicants can apply for. But I would encourage you to reach out to those the Department of Cannabis Control to see what funding and waiver programs they have available, because it changes and it's always subject to the availability of funding.
From Emily H. Does the individual who is identified as the successor in interest need to be a verified social equity applicant?
No, they do not. The intent of the successor in interest form is, in the event of the death of a bona fide social equity individual applicant, that individual has identified their successor, and for DCR's renewal process, equity share review, etc., we would basically put that successor in the shoes of the verified social equity individual applicant. So they do not have to be verified in their own right to be a successor in interest. They do have to be a natural person. So a successor in interest can't be an entity or a trust or something else.
Question from Simon. Can I designate any non-minor friend or family to be my successor in interest? I have no other family, trust, or will.
For the purposes of our form, yes. But you may want to make sure that you develop a last will and testament that reflects what your intentions are. So should your estate be challenged after your passing, your successor isn't by court order removed from the DCR record. Again, that's a really good question, and unfortunately, we can't provide business or legal advice. I can tell you that you can designate a non-minor to be your successor in interest, but there may be things that you as an individual have to do on the back end to make sure that your decision is not later challenged in court.
A question from MS. How come renewal fees are more expensive for 2025 than they were for 2024? I believe the director either pulled, let's see, even though the similar account of documents are required to be submitted.
So the renewal fees are set by the municipal code. The renewal fees for calendar year 2024 were reduced because we were in negotiations with the Department of Cannabis Control in terms of what LJAG funds could be used to waive applicable fees to convert people from provisional licensure to annual licensure. So it's not that the fee amount was different. The fees that we know were not eligible were assessed, and we deferred the remainder of the mandated municipal code renewal fee in hopes that the LJAG funding could be utilized. We started this LJAG amendment process in April of 2023, and we're in September of 2024, and it hasn't been approved yet. And we continue to have conversations with them. So, we can't unfortunately continue to kick the can down the road in hopes that the state is going to approve a grant expenditure plan to cover these fees, especially since the grant performance period expires on March 31st of 2025. So the director used her discretion to defer fees that otherwise would have been due because we hoped that the state grant funds could be used to pay them. We are not in a position to do that same thing for calendar year 2025.
And then last question, if you can bear it, from Quantleaf Labs, state imposed deadline for us to submit CEQA as we finish the process with them for everything else. To clarify, we finished all reviews, satisfy the criteria with the state for annual testing lab license. Nothing else is outstanding. We have a deadline imposed. If not submitted, the application will be abandoned. What can we do?
This is going to be something that's directly related to an application and an analyst, and I believe that an email inquiry has already come in. So this is going to have to be something we handle outside of the Q&A session. And I do have like 5 more minutes if there are any outstanding questions before I have to hop.
From MS, if an EMMD has multiple activities, which are now bundled under an LIC record, will they only need to submit one renewal application and pay $8,486 only once, or is the annual license fee of $8,486 still per activity?
It's still per activity.
From Razy, is there someone I can speak to regarding the distribution of licenses? Trying to understand the next part of the question. Bear with me. I'll just read it as is. No one seemed to be looking at the numbers of users per community that determine the success or failure of a dispensary, especially a social equity licensed dispensary.
So based on Measure M and the policies adopted by the mayor and city council, DCR has the authority to issue a certain number of licenses in each community plan area. We do keep track of that. That information is posted on the department's website. And that is the guiding document. Once a community plan area reaches undue concentration, any additional applications would have to first be approved for processing by the city council, and determining like a need is part of that PCN process, which determines whether or not there's a public convenience or necessity tied to the approval of an additional application. But we're not going to unilaterally, when there's 10 licenses available in a CPA and 2 have been issued, tell the third applicant, no, we don't think that there's a need for a third license here. You're denied. We don't have the authority under the code to do that.
And the last question from Levon. What retail type 10 licenses don't count towards undue concentration?
And the most basic colloquial way I can phrase it is type 10 phase 1 licenses are not subject to a finding of undue concentration. So the existing medical marijuana dispensaries count towards the calculation, but they are not subject to the finding. So for instance, like Central City, which covers downtown LA, we are unduly concentrated due to phase 1, and DCR had the authority to grant more licenses than would have been available based on the ratio of licenses to constituents in that area. Separately, as part of phase 3 retail round 3, when the city council authorized the additional 100 licenses, they exempted the initial 100 licenses from the calculation. So the first 100 in phase 3 round 1 don't get added into whether or not a community plan area is unduly concentrated. And undue concentration currently is based on the issuance of a license. So really it's us having to track on a record by record basis whether or not something gets added into the calculation or is outside of the calculation. To the best of my ability, I've tried to outline that information on the DCR website that has the licensing map. Just below the licensing map, there is a table that has a tab for retail storefront and then for the cultivation activity. Both of those activity types are subject to findings of undue concentration. And, I updated them either earlier this month or last month. So you kind of have a general understanding of how many licenses are currently available based on each community plan area.
Thank you so much, Jason. I think we're through with questions.
I really appreciate it. I'm thankful for all of the DCR team members that were able to stick around and go over today. And I'm especially thankful to all of the participants who, participated in the Q&A session, submitted questions, stuck around to hear me talk for over an hour and a half. Our next Q&A virtual lunch is going to be on Wednesday, October 23rd at noon. So if you didn't get your questions asked or answered, or you have additional questions that you want to ask, please get them submitted and we'll do our best to get them addressed on October 23rd. Thank you all. Have a great day. Bye.